Okay, so actually I'm gonna take Evans first because I need to move them. And then I'll take Jocelyn and then Cholik. Mr. Flanagan, did you have an opportunity to look up the balance on that review for Cholik?
No, let me look that up.
Okay, thank you. Miss Davis, please start your video. Oh, we didn't. Miss Davis, you probably might need to put on a shirt, but just hold, I mean, a jacket. Just hold tight. Because, ma'am, I said hold tight. I said hold tight. I said hold tight. Okay. All right, this is case number 224454601, the people of the state of Michigan versus Shardaeus Evans. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505. I also have the complainant witness present via Zoom this morning. Ms. Davis, state your name for the court, please.
Unmute and state your name, please. Ma'am, state your name, please. She can't.
Yeah, she's unmuted. I think she's having audio issues.
Well, no, she must be because she's not even moving her mouth. Let me send a thing. She's not. I mean, she sure got up off that thing. I guess we should have brought her in before. Ms. Stevenson, go ahead.
Janice Stevenson appearing on behalf of Mr. Shardaeus Evans. Mr. Evans, sir, please tell the judge your full name.
Shardaeus Evans.
Thank you. Ms. Ritter, you may have to call your witness. Do you have her phone number?
I do, Judge.
All right, call her. You don't have to call. I mean, you can call her and tell her to log into the next courtroom, but she needs to check her situation. So today is the date set for pretrial conference. Ms. Ritter.
Judge, I had an opportunity to speak with Ms. Davis prior to today's pretrial conference. And from my understanding,
can't hear anything.
Okay,
well,
but
we can hear you now.
But you're not gonna be able to talk though, because we can hear you. We can hear you. Okay, tell her to stop talking.
Ms. Davis.
Okay. Go ahead, Miss Ritter.
So, Judge, I had an opportunity to speak with Ms. Davis prior to today's pretrial conference, and I believe that, from my understanding of the conversation, Mr. Evans is Ms. Davis's son, and the people believe this case will be best suited for the domestic violence docket.
All right. The court is going to transfer the case to the non-intimate partner domestic violence docket with Judge Austin Garrett, and Judge Baltimore said that the parties can log on now. So Mr. Evans, how did you log into my courtroom? Hey, come on.
On my phone.
No, I mean, I apologize. Let me be clearer.
I'm in the waiting room.
Ma'am, you
from
talking,
my phone.
You talking. If she unmute one more time, I don't know. But what I'm getting ready to remove her. Let me stop her from being able to unmute. Okay. Mr. Evans, what I meant was, did you type in my Zoom ID number, or
I can't hear you guys at all.
Blessed assurance, if this baby unmute one more time. Why can't she hear you? I don't know. And why can't she unmute? Because I stopped them from being able to unmute. Okay. Did you log in using my name, or did you type in the Zoom ID?
Zoom ID.
So do you have that Zoom ID in front of you?
Yes.
Right. Look at it. Do you see the middle numbers? It says 339.
Yes.
Instead of 9, you're going to type in 8, and that's going to put you in Judge Garrett's courtroom.
All right.
They are expecting you. So go ahead and I'm gonna remove you from my Zoom and then you can log into Judge Austin Garrett's courtroom and they're expecting you.
Okay.
All right, have a great day. Stay safe.
Thank you. You too.
All right, Miss Ritter, are you talking to Miss Davis?
Yes, Judge, I have Ms. Davis on the phone. She just can't hear on Zoom.
She
And she has a
got
device.
some, got that, well, because she got that Bluetooth in that's not connected to the thing. She needs to take out that Bluetooth, but just send her over to Judge Garrett and tell her to take that Bluetooth off because it's not working. The Bluetooth.
I
is
will,
not-
Judge.
Okay, all right.
Thank
thank you. And I'm gonna handle Mr. Forrest's case and this review, so you good for now anyway. So help her get to Judge Garrett. All right. Let me stop her video because she's not gonna even log up.
I'm
Okay.
heading back in, Judge.
Yes, you can head back in, Ms. Stevenson. Thank you.
Welcome.
Good morning, Mr. Forrest. Oh, wait, I had to change the settings because she kept unmuting. All right. Good morning, Mr. Forrest.
Good morning, Your Honor. How are you this morning?
I'm wonderful, thank you. All right, how are you?
Excellent, thank you.
Okay, I'm actually gonna do Mr. Awada's client first, and because it's gonna be quicker, and then Mr. Penny is here, and I'm ready for your sentencing, okay?
Very good, thank you.
All right. I'm letting your client in, counsel. And then give me one moment. All right, this is case number. What happened to the lawyer on, Miss McLean. So actually, you're gonna be before the sentencing. I apologize, I forgot you were there.
No worries, Judge. It's,
All right.
it's not a problem. Thank you, though.
All right, thank you. This is case number 19446. No, yes, 446-3001. The people of the state of Michigan versus Mike Raymond. Last name is Cholagh. Defendant is charged with 1 count of gambling, disassociated person, and today is the date set for review. Counsel, your appearance, please.
Good morning, Your Honor. Mark Awada, P numbers 58029 on behalf of the defendant, Mr. Chola.
And Mr. Chola, state your name, please.
Mike Raymond Cholagh.
All right, today is the date set by the magistrates for a review. Mr. Chola must have been habeas for some time. I had an opportunity to look at the sentencing for Mr. Chola, and Mr. Chola was sentenced by Judge Kenneth King on May 15th, 2019. He was only ordered to do 2 things, well, probably 3. No new offenses. He was supposed to pay $910, and he was supposed to engage in gamblers counseling. He was placed on probation for 1 year. And he still has a big balance. Counsel, has your client done anything? He still owes all of the money.
Your Honor, later that year, he was incarcerated and he spent 2 years in the MDOC on a firearms charge.
Oh, okay, so
3 years.
3 years. I apologize.
All right, well then, council, let's do this. I will adjourn this review. If you can just submit proof that he, proof of the incarceration, then I will waive those fees, and I will close his case out.
Thank you, Your Honor.
All right, I'm gonna give you my clerk's email address. Well, Mr. Flanagan, put your email address in the chat to Mr. Awada.
Yes, Your Honor.
And then Mr. Chola, say your name again.
Chola.
Chola. Mr. Chola, upon verification that you did spend 3 years in the Michigan Department of Corrections, then I will amend your sentencing. I will sentence you to 93 days in the Wayne County Jail, credit for 93 days served, and close the case out, okay?
All right, thank you.
All right, counsel, when do you think you'll get that to my clerk?
Your Honor, if it doesn't have to be a certified copy, I can get it relatively quickly within
doesn't
7
have-
days.
It doesn't have to be certified, because once you send it to us, we're gonna look them up on Otis.
All right. Thank you, Your Honor.
All right, anything, yeah, yes,
Probation
sir.
officer already has it. My probation officer already has it.
Oh, who was your probation officer? I thought it said non-reporting.
Yeah, I'll tell you her name right now. She
Yeah.
talked to me yesterday.
Okay, tell me her name.
McCall.
All right, thank you. Mr. Flanagan, call Ms. McCall and see if she could forward that to you. So then, once I receive it from Ms. McCall, then I will amend his sentence and close him out, okay?
Thank you, Your Honor.
All right, so counsel, why don't you give my clerk your phone number? We'll call you to let you know if we still need something from you.
Your Honor, my chat's disabled. Is it okay if I just say it?
If you want the people on.
Oh, yeah, it's, thank you.
I'll enable it. Okay, there you go.
All right. Thank you, Your Honor.
All right, you're welcome. Okay, I'm ready on Jocelyn, and then I'll take Mr. Forrest's case. Okay, so this is a free trial. This is probably more of what you'll be doing. Only sometimes. So like I am right now, but only when all right, I'm ready on Jocelyn. This is case number 234423301. The people of the state of Michigan versus Susan Smith Jocelyn. Defendant is charged with 1 count of assault or assault and battery. And today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning again, Your Honor. Laura McLean on behalf of the defendant, Susan Jocelyn.
And your P number, counsel.
Oh, yes, sorry, Judge. It's P77695.
Ms. Jocelyn, unmute and state your name. Oh, well, you should be able to unmute.
Susan Jocelyn.
All right, thank you. Today is the date set for pretrial conference. How are we proceeding?
Your Honor, I have spoken with Ms. Ritter, and it's my understanding that she has made attempts to contact the complaining witness. Per our last conversation, she was unable to contact him. I will leave it to her to update the court from there.
Ms. Ritter?
Your Honor, so today, is the day for a pretrial conference. The court did arraign this matter and required the complaining witness to be present for today's hearing. I don't see the complaining witness by name, Donovan Shaver, in the waiting room, Judge. In the event the two unidentified phones are not Mr. Shaver in this matter, I have no explanation as to why he is not present, as the court required his presence for today's hearing. And at this time, the people will not be able to proceed based on the complaining witness's failure to appear today.
So we would be, oh, I'm sorry, Judge.
Hold on one second, counsel. Will the individual on the telephone ending in 6099 please press *6 to unmute? Oh, wait, did they leave? No. All right, please press *6 to unmute and state your name. The individual on a telephone ending in 6099, please press *6 to unmute and state your name.
Yeah, I'm a little tired.
All right, the person won't unmute. Ms. McLean?
Yes, Your Honor, as the complaining witness has failed to appear, despite Ms. Ritter's attempts to contact them and their failure to appear here today, we'd ask that the court dismiss this matter.
The person that's on the telephone that unmuted, state your name for me.
Pamela Halliburton.
Ms. Ritter, what was the complaining witness's name?
Mr. Donovan Shaver.
Oh, Pamela Halliburton. Ms. Halliburton, I see you are on my docket for
Yes.
arraignment. I'm going to send your device to a breakout room. However, you must be on video to attend court. You may have to come in person, but I'm going to send you to the breakout room. A lawyer will come in to speak with you, okay?
Okay,
Thank you.
thank you.
All right. With respect to Ms. Jocelyn, today is the date set for a pretrial conference. While it is the first scheduling of the pretrial conference, the court did arraign this matter and require the complaining witness to appear. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure, and they are unable to proceed at this time. The court is therefore going to grant defense counsel's motion and dismiss the matter without prejudice. Ms. McLean, are you able to submit an order of dismissal to my court?
Absolutely, Judge. I'll do that today.
All right, Mr. Flanagan, please put your email address in the chat for Ms. McLean. And then Ms. Jocelyn, your lawyer will get a copy of that dismissal for your records, okay?
Yes, Your Honor.
Have a great day and stay safe.
Thank you.
Thank you, Judge.
You're welcome. What's her name? She here for, oh, she here for sentencing. All right, I'm ready on pen. Mr. Forrest? Mr. Forrest, are you there?
I just shot him a text to please come back. Mr. Forrest just said he just got pulled back into a courtroom and he's going to come back in just a moment.
Okay, thank you. Then let me try to see. So, okay, thank you, counsel. So this is Wednesday. That's Wednesday, without this part at the bottom. So. Where's Tuesday? That's not gonna. Because you know we are here on that. Oh, yeah, so. If it's on for an arraignment, for an arraignment. I don't know. My bonds are personal, but. So my bonds are personal, okay, for the most part, and. Oh, here it is, okay. My bonds are personal. And I don't believe in them tethers. That bill them keep on putting on all the people. Unless they really are fighting. Right, so, I mean, I'll do a tether on, Mr. Ford's back, I'll do a tether on, like an aggravated assault, I might leave a tether on, or stalking. Like those, I might leave a tether on. I'm gonna defer the sentence then. But. So that's the only thing that won't be on here, and then we could go over that in a minute. Okay. All right. I wasn't even. Oh, okay, we weren't even muted, I was just talking, we weren't even muted that last time, all right. I'm ready. Let me bring in Mr. Forrest's client.
It looks like she's in.
Oh, is she? Oh, yes, she is. Okay. Ms. Penn, start your video. Mr. Flanagan,
Yes, Your Honor.
can you call Miss Cameron and see if she is actually the lawyer on Newsom?
Yes, ma'am.
All right, thank you. And then where are my sentencing forms? See, this one have to be. And then, and I am gonna leave you dates, so to set the pre-trials for the final pre-trials, I'll leave you dates. Okay, I'm ready on pen. This is case number 23. I'm sorry, y'all get, hold on one second. Oh, there we go. Okay. All right, this is case number 23443740. The people of the state of Michigan versus Felicity X Penn. The defendant is charged with one count of operating while visibly impaired. And today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Matthew Penny, P74079 for the people.
Good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of Felicity Penn, who's present via Zoom.
Ms. Penn, unmute and state your name.
Felicity Penn.
Thank you. All right. Today is the date set. Oh, her middle name is Xavier. I thought I saw a middle name. It was on the PSIR. All right, today is the date set for sentencing. And the court has had an opportunity to review the pre-sentence report. With respect to the pre-sentence report itself, are there any additions, deletions, or corrections on behalf of the people?
No, Your Honor.
On behalf of the defense?
No, Your Honor.
With respect to sentencing, is there anything on behalf of the people?
We just asked the court to adopt the sentence agreement and move forward.
Any thing on behalf of the defense?
Yes, Your Honor. This offense represents Ms. Penn's first contact with the criminal justice system. She has taken this very seriously since the outset of this case and understands the error of her ways in this matter. And, based on my discussions with her, she is committed to not being in this situation or doing anything like this ever again. We have reached a agreement with the prosecutor's office. We asked the court to adopt it. I believe that it is reasonable and fair given the circumstances and Ms. Penn's background. And that's all I have at this time, Judge.
All right, Ms. Penn, would you like to make any statement on your own behalf?
Yes, ma'am.
You may.
I'd like to sincerely apologize for my actions. I do understand the gravity, the gravity of what I done and the gravity of what the outcomes could have been. And I'm truly blessed, and the people around me are truly blessed that nothing worse happened. I made this mistake, and I'm truly sorry for it. I don't plan on ever making a mistake like this again. I understand that it is my fault that everything happened within everything because of the neglect of making good decisions and thinking, having compassion for others within that moment.
All right. The court is ready to impose sentence, and Ms. Penn, I'm gonna say something. I was watching court TV the other day. I don't know why I watch court TV all the time after I leave work, but I do. And Ms. Penn, one of the things that really it was just so devastating to me. One of the stories that they were doing on court TV was the story of a bride, and literally a bride who had just gotten married on the beach. And they were taking pictures and whatnot after the ceremony. They got on I think they said they got on a golf cart or something, and they were driving over to another location just on the resort. And she was hit by a drunk driver and killed. Literally, she had just gotten married. I'm very passionate about drinking and driving. When I first became a judge, I used to put people in jail on the first offense. And then a little time passed and I became more interested in helping the individual to get better, change their life, stop drinking, make better choices. So I appreciate your apology today, just to the court system and to society as a whole. I'm thankful that you're on my docket. What do I mean by that? The fact that you're on my docket means nobody died. It means it's not your third time within a certain period. Otherwise, you would be on the felony docket. So I'm thankful that even though you made a bad decision to drink and drive, that it wasn't serious enough to not be on my docket. Drinking and driving is a serious situation, and we should just all be cognizant of that fact, especially in a day and time where you can call an Uber, a Lyft, anything, and not have to drink and drive. Okay, so I do appreciate your apology, and I am going to accept the recommendation of probation. I'm going to sentence you to a term of probation for 12 months. That will put us with a final review date of today is August 3rd. That's the week. So August the 2nd of 2024. If you get to that point, you will be eligible for early discharge after 6 months. So I'm going to give you a 6-month review date. That 6-month review date will be February the 6th of 2024 at 10:00 a.m. If you have completed the terms and conditions of probation that I'm going to give you, then you will be eligible to be discharged early from probation. in February. If you don't, there's no penalty in February. You just continue to the, later review date, okay? Court is going to impose the following fines, costs, and fees: $210 mandatory cost, a $350 fine, no restitution, Mr. Penny, nothing, no restitution.
No, Your Honor.
All right. The court is going to impose supervision fees at a rate of $35 a month for a total of $420 and a $100 pre-sentence investigation fee. I got ahead of myself. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of the court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. Your total fines, costs, and fees is $1,080. If you are discharged early, we will prorate the supervision fee. So if you plan to get discharged at 6 months, then you only need to have paid $870, and we will waive the rest if you get discharged early. Ma'am, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor as to why they would prescribe such an addicting narcotic. You shall not consume any alcohol in any form. You shall not drive without a valid driver's license. According to this report, your driver's license is restricted. So whatever the Secretary of State's restrictions are, you can only drive within those restrictions. You shall attend and complete the Alcohol Highway Safety Program Level 1. You shall submit to random urinalysis twice per month. If you do not have any positive tests after 3 months, it can be reduced to once a month. You shall attend and complete the Victims Impact Panel, watch the consequences video. You shall only attend, I think there was a recommendation. Yeah, there was a recommendation for outpatient treatment. And I'm going to indicate outpatient treatment if you have any positive tests, okay? So
Judge, the alcohol.
Oh,
I'm sorry.
Go
The
ahead.
alcohol counseling was one of the terms of the plea.
Oh, okay, well then you're gonna go to alcohol counseling. Thank you, counsel.
No problem, Judge.
Oh, you will attend, you are correct, it's on here. You will attend alcohol or outpatient treatment. And I'm not going to order that you attend any 12-step program unless it's recommended by your therapist, by your counselor. Let's see. And the court notes that the offer was for no deferred, delayed, or special sentencing. You shall also attend the driver's improvement program. If you have any outstanding tickets with the 36th District Court, you shall pay them. This report says you have none. If you have any outstanding warrants anywhere, you must clear them up. The report says you have none, but we will run the lien again before you are discharged. We will mail a copy of the court's order to the Waltham Street address, and probation will contact you at the phone number ending in 8689. Is there anything further?
Judge, would you mind emailing me a copy of that sentence and order as well?
Mr. Flanagan, do you have Mr. Penny's email address?
Counsel, if you could just put it in the chat, just to confirm it, I do believe I have
Absolutely.
it.
Thank you.
All right. Mr. Forrest, would you like a copy also? Or you?
I would, thank you.
Okay. So just make a note on this to send it to all counsel and then mail it to Ms. Penn.
Okay.
Mr. Penny, can I give you some information?
Sure.
May I give you some information?
Absolutely.
In negotiating your settlements for your cases, keep in mind, it doesn't apply for this case because there was no sobriety court referral or anything. But let your office know, because I've gotten a few of them, that if you're negotiating for sobriety court, drug court, mental health court, Veterans Court, Judge Holmes requires 14 months. The program requires 14 months probation, not 12 months.
I am making a note of that right now.
Okay.
Thanks, Judge.
All right, you're welcome. Anything further?
No,
Not
Your
from
Honor.
the people. Thank you.
You all have a great day. Stay safe.
Thanks, you as well.
You as well.
All right, I got a lot of attorneys today. I think Miss Taylor Coleman was next. Oh, she left. She left. She must have had something to do. So, but yeah, if you like it, if you think you want to just, at least be. Good morning, Ms. Castor.
Good morning, Your Honor. How are you?
I'm wonderful, thank you. How are you?
Doing well, thank you.
You're here on Chicago.
Yes, Your Honor.
Did you receive the PSIR?
I have, and we've gone over it.
All right. There's a couple of cases in front of you, but I will be with you shortly if you will be patient with me for a little bit.
Of course, Your Honor.
All
Yes.
right. Thank you.
Thank you.
Okay, look, Miss Ritter, I'm training one of the judges for next week, so you just know they gonna be on it. They're gonna be on it. All right, let's see. Well, my other two lawyers are not here, so I get, oh, there's Miss Coleman. All right. So that means I'm ready on Rambus. We're ready on Rambus. And I will bring Miss Rambus in. Let me bring in Miss Newsom. I think Miss Cameron is still her lawyer. I'll ask her. And then
Okay.
you might have to keep trying. Miss Rambus, turn on your camera. Miss Newsom. All right, Miss Newsom, have you talked to Miss Cameron? She's your lawyer, right?
Yes, ma'am. I haven't spoken with her. She's usually always on point and on time.
She is. And we tried to call her and her voicemail is full. So I'm just waiting on, I am waiting on her. But we're gonna keep trying to call her, okay?
Yes, ma'am.
She's usually, you're right, she's usually on point and on time. So we're gonna keep calling her. Maybe she got caught up in another court hearing, okay?
Yes, ma'am.
Okay,
Okay, thank you.
you're welcome. All right, well, Mr. Flanagan, just keep calling.
Yes, ma'am.
All right. Hold on, what am I doing? Oh, okay, that's for Ramsey, okay. Oh, but is his client with him?
Yes, the client's in the courtroom, Your Honor.
Oh, okay, thank you. All right, I'm ready on Rambus, not Ramsey. I'm ready on Rambus. This is case number 204412701, the people of the state of Michigan versus Virginia Rambus. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor, in court, Delisha Taylor Coleman, P56278 on behalf of Virginia Rambus. I have not received the PSI.
Ms. Rambus, state your name.
Virginia Rambus.
All right, today is the day set for sentencing. Ms. Taylor Coleman, I set this matter at 8:59. That says to me that we didn't order a pre-sentence investigation, and I usually would have asked, but if you are requesting one, I can order one.
Nope, not requesting one, Your Honor.
Okay.
I just wasn't sure, so I apologize.
Yes, no, that's fine. Yeah, I set it at 8:59. That lets me know that that one wasn't ordered, and that usually means that none was requested. I think I asked. Ms. Ritter, is that your understanding?
That is, Judge, and that's what my notes indicate as well.
Okay, so that being said, and I think I set it for sentencing, even though I didn't order the pre-sentence report, so that the victim, if they chose, could appear. So with respect to sentencing, Ms. Ritter, is your victim present, or is there anything on behalf of the people?
Judge, I don't see the complainant witness or now victim, Ms. LaShonda Reed, in the waiting room by that name, Judge. I just see a telephone number, but I believe that was the same number that tried to log in earlier this morning. Other than that, Judge, as far as sentencing, Your Honor, there was a recommendation from the people for a term of probation, at least 12 weeks of anger management, no contact with the victim, Ms. LaShonda Reed. And Your Honor, the people had no objection to a delayed sentence. I believe this case happened back in 2020. And at that time.
27. Hold on, ma'am. Please don't interrupt. Thank you so much. Ms. Ritter.
I'm sorry, Judge, it happened back in 2019. So at that time, when I looked at the criminal history listed in the file, I didn't see anything that would make Ms. Rambis ineligible for a delayed sentence at this time.
And did the people have a recommendation or request as to the length of probation?
I do not, Judge.
Thank you. Can the individual on the telephone that's not on a video device, can you please state your name?
Pamela Halliburton. I had to get another telephone to use so I can go to the video.
Well, you're not on video though, Ms. Halliburton. You're still on, you still called in. You didn't Zoom in.
Oh my goodness. Okay. Can I switch you over real quick to Zoom?
I'm gonna put you in a breakout room. I don't know what you mean, but the lawyers will have to help you. I'm in the middle of a hearing. All right.
Oh, I'm sorry.
All right, Ms. Taylor Coleman, anything on behalf of your client?
Yes, Your Honor. Ms. Rambis has, she's very regrettable that this situation occurred. She has gone through a divorce, loss of job, intense and emotional distress for herself and her family. She understands the seriousness and significance, has not had any contact, would not have any contact with the complaining witness, and now her ex-husband. We would ask the court to 9 months probation. She's in the process of getting another job. She was recently just employed with, I believe, the school system, but has lost that job and in the process of getting another one. She's just deeply regretful that the situation occurred. And we would ask the court to put it under 771 so that she could get this off of her record, and she does not and has not in all of her years had a frame of conviction.
All right, and Ms. Rambis, would you like to make any statement on your own behalf?
No.
All right, the court is ready to impose sentence. I will do so in the following manner. Court will accept the recommendation. Well, the court will sentence Ms. Rambis to a probationary period, and I will accept Ms. Taylor Coleman's request for a 9-month probationary period. That will place a final review date of May the 2nd, 2024. Additionally, you will be eligible for early discharge at 4.5 months. So the court will set a midway review date for January 31st at 10 o'clock. If you have completed the terms and conditions of the probation, then you will be eligible for the early discharge. The terms and conditions of your probation are: you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must, I'm going to make this a non-reporting probation. That means you're going to have to make sure that you follow up with the classes that I am going to order. We will put the telephone number, the contact information in your probation order, and then you must make sure that you follow up and sign up for those classes. If you come back at the halfway point and you haven't done anything, I'm going to switch it to reporting. I'm going to switch it to a reporting probation so you can report to probation. So right now it's non-reporting. And the court is going to impose these terms. Mandatory cost of $210, a $250 fine. At this time, I don't have any requests for restitution. Since it's non-reporting at this time, there's no supervision fees, and I did not order a pre-sentence investigation, so there's no fee. So the total cost at this time is $460. Additionally, you shall not use or possess any illegal substances. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management. You shall have no contact with the complaining witness, and you shall attend the eVay Choices program. Both of those programs are online, I believe. I think they still are doing online options. Since I did not do a pre-sentence investigation, I do not have updated information on Ms. Rambis. So Ms. Taylor Coleman, if you could make sure that Mr. Flanagan has the current address and phone number for Ms. Rambis, so that we can make sure that if we need to get in touch with her, then we'll be able to get in touch with her. All right, and we can mail a copy of the probation order. Anything further?
Not from the people, Judge. Thank you.
Not from defense. Thank you, Your Honor.
All right, ma'am, then you're all set, and I will see you January 31st at 10 o'clock, okay?
Thank you.
You're welcome.
Judge, can I step away from my device very quickly?
Sure.
Oh.
Mr. Hamilton, good morning. Did y'all hear me? I didn't hear him.
Yes, good morning.
Mr. Hamilton, did you receive the pre-sentence investigation for your client?
Yes, Your Honor.
All right, well, when the prosecutor comes back, then I'll be, well, I'm strike that. There's one sentencing in front of you. I'm sorry. I'm gonna take Ms. Castoff. So, Mr. Flanagan?
Yes, Your Honor.
I thought I saw Mr. Land in the waiting room. He's no longer there. But when I'm ready, so let's see, Mr. Land also has, oh no, Mr. Land is the attorney for court for Anderson. Oh, can you send me the register of action for Corey Anderson?
Yes, Your Honor.
Ms. Castoff, you're up next, but the prosecutor stepped away briefly, so when she comes back, and then I'm gonna step away briefly, but
No problem, Judge. And just
my
to
brief
make,
might be briefer than her brief. Yes.
sorry, this is an AG case. Is it okay that it's,
Oh, I didn't even realize it.
yeah, let me, I can
Yeah,
get.
they're not here. Oh,
Okay.
it's 9:56. What AG is this? What AG is this? Okay.
I'll try to get in contact with that AG judge.
Who is it? Do you know?
It's in my notes. I have her contact, I believe. So I'm sorry. No, this is a male AG. This is Mr. Hold on one sec. You know what, actually?
Well, Mr. Flanagan, call him. It's either Mr. Hey.
No, I apologize, Judge. This is a special prosecutor from Monroe County. His name is John Landis, and that's because we had a conflict with the Wayne County Prosecutor's Office. So I can call him.
Oh, he must not. Yeah, he's from another county. He didn't realize who courtroom he was supposed to show up in. It's 10 o'clock.
I'll call him, Judge. I have his contact.
Okay, thank you. All right, all right. Okay, well now, Mr. Hamilton, you get to jump ahead because we have to wait. So give me 1 second and I'll be right back. I'm ready on Ramsey. Also, I'm in the building. Did you all want me to come downstairs or are you fine with me being on Zoom?
Zoom is fine, Your Honor.
All right. This is case number 235709001, the people of the state of Michigan versus Larome Ramsey. Defendant is charged with one count of understand his charges. Oh, unlawful use of a motor vehicle. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Vanessa Hamilton, PA 2107, on behalf of Mr. Ramsey, who joins me in the courtroom to my right. Could you say your name for the record?
Larome Ramsey.
All right, today is the date set for sentencing. I've had an opportunity to review the pre-sentence report. And on behalf of the people, are there any additions, deletions, or corrections? I can't see.
Judge, the people had an opportunity to review the pre-sentence report. I don't have any additions, deletions, or corrections as far as the sentencing report itself. However, the ROA reflects a different amendment to the original count. I'm sorry, the original count one, receiving and concealing stolen property, was amended to unlawful use of a motor vehicle. And the ROA reflects that there was an attempt modification added on that count.
Oh, what does the ROA say?
It says unlawful use of a motor vehicle attempt.
Oh, Mr. Flanagan, can you correct that?
Yes, Your Honor.
And counsel, correct me if I'm wrong, but it was just unlawful use of a motor vehicle, the 90-day misdemeanor, no attempts.
Yes, that's correct.
Okay. So I just wanted to put that on the record, Judge, but the plea agreement states that the terms and conditions could be set by the court, and the delayed sentencing under 771 was approved for this particular charge, Your Honor.
Well, I have a question about that.
Yes, Your
Honor. This was a felony, right?
That's correct.
Okay. Well, I'm gonna save my question until allocution. Counsel, are there any additions, deletions, or corrections on behalf of Mr. Ramsey?
No, Your Honor, nothing on behalf of the defense. The report is reflects correct information.
Okay. So with respect to sentencing, Ms. Ritter, I guess my question is with respect to HIDA. I'm looking at, so there was a negotiation for 771. Mr. Ramsey is 19. And then the plea agreement, strike that. The PSIR says HIDA no, but I'm assuming that's just because it's not that he's not eligible for HIDA, it's just that HIDA apparently wasn't offered. Is there any reason why the people didn't offer HIDA?
Judge, and I asked Mr. Flanagan to send me a copy of the plea agreement, which he did. And that's what I was trying to figure out what was going on with that. But I guess the felony APA decided to grant 771. But if the court doesn't have a problem with modifying that to HIDA, I don't have a problem with that. Judge, because it looks like Mr. Ramsey does not have a prior criminal history or anything that will prevent him from taking advantage of HIDA.
You're correct. I could be wrong, but my understanding was HIDA is only applicable for felonies.
Oh, no, you're wrong. No, that's wrong. We give HIDA all the time in this courtroom. HIDA is applicable to misdemeanors as well. And then Ms. Ritter, with respect to his age, he's still at the age where I don't need the people's consent, isn't he?
That's correct, Judge.
Okay, all right. Okay, anything further, or I apologize, anything on behalf of Mr. Ramsey?
Not from the people, Judge. Thank you.
Your Honor, we just wanted to state, what the court has already picked up on is that Mr. Ramsey is 19 years old. He has no previous record whatsoever. And in this particular case, it was just kind of a situation of hanging out with the wrong people. But there's nothing in his conduct that's been assaultive or anything of that nature. And once again, this is his first contact with law enforcement ever. So I guess we would either be looking for that delayed sentence or for HIDA, whichever the court prefers.
Okay, Mr. Ramsey, do you want to make any statement on your own behalf?
No.
All right, so, the court has had an opportunity to review the pre-sentence report. Mr. Ramsey appears before this court, a young man. According to his counsel, he was hanging out with the wrong people. You got sometimes you got dump people, because now you're the only one standing in front of me. I don't know what happened to the other people, but I am going to sentence Mr. Ramsey in line with the probation recommendation, except the court is going to switch it out. And I am going to sentence you pursuant to HIDA. That makes it easier for you to do certain things, get a job, do some other stuff while the case is pending. So moving forward from today, the case is going to be suppressed under HIDA. So if you're looking for a job and that kind of thing, your potential employers won't be able to see the case. And I am going to impose the following conditions. So, number one, I did notice that you, according to the report, that you didn't yet finish high school, but you're currently working on that. Is that correct? Are you currently enrolled in an adult education program?
Yes.
Okay, so the court is going to impose the following conditions. Of course, you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without my consent. You must notify probation of any change of your address, phone number, or employment status, and you must make a truthful report to probation on a monthly basis. I am going to impose a 12-month probationary period under HIDA. That puts a final review date for August the 2nd, 2024. However, you are eligible to be discharged early from this probation as early as February the 6th of 2024. So I'm going to set a review for February the 6th. If you have completed the terms and conditions of the probation, then you will be eligible for the early discharge. I am going to impose the mandatory cost of $210. I am going to waive the other costs, and I'm going to accept probation's recommendation for the 10 days of community service. Now, probation said 10 days of community service plus they recommended a $300 fine. I'm not doing that. I've only, and I'm going to impose a $35 pre-sentence investigation fee, not a $100 pre-sentence investigation fee. I am going to waive the oversight fees. I shouldn't say waive them. I'm going to convert the oversight fees, the fines, and the supervision fees, the fine. That will be it, to community service, and that's where the 10 days of community service is going to come in. 10 days of community service is equivalent to 80 hours. 80 hours. So a full day is 8 hours. That's how we count the days. Additionally, I'm going to have you just attend and complete the Choices program through eVay. You shall not use or possess any illegal substances. You shall not drive without a valid driver's license. And that's it. That's all. All right. You're going to come back to see me February the 6th. If you have paid the $235 plus completed the Choices program and the community service, then I will discharge you from probation. If you have not in February, there's no penalty. There's no penalty in February if you have not, but you'll just be continued on for the, duration of probation. But if you get finished early, you can get discharged early. Mr. Flanagan, are we able to give him a copy of the report since he's in person?
Your Honor, the system is not letting me remove attempt from the ROA, so I need to take this to Ms. Knight later today.
Okay, so then, sir, we're going to mail you a copy of my probation order to the Sherman Street address, and then probation will contact you at the phone number ending in 4537. Is there anything further?
Not from the people, Judge.
Nothing additional, Your Honor.
Okay, then we're all set. Everyone have a great day and stay safe.
Thank you.
All right. Ms. Stevenson, you got a reprieve today. You could take as long as you wanted because I had a lot of retained and appointed counsel.
And I appreciate that so much, Your Honor.
Right, because you were working on by yourself and stuff.
And
I wasn't sending you text.
Right.
Hurry up and come on.
Right.
All right, I'm ready on Brown. I am ready on Brown. I know, but that was before I could see. Oh, you might have to wait. Better pick on yourself. Okay, I'm ready on Brown. This is case number. Oh, wait a minute. I'm sorry. What was the name of that person she told me? Oh, there he is in the waiting room right now. Okay. This is case number 22-450021. The people of the state of Michigan versus Sharnice Brown. Sharnice Lachey or LaShawn Brown. Defendant is charged with 1 count of assault aggravated. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Sharnessa Brown. Ms. Brown, ma'am, please unmute and tell the judge your full name.
LaShawn Brown.
Say that again for me, please.
Charnessa LaShawn Brown.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
On behalf of Ms. Brown, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, the court scheduled this pre-trial conference at 8:25, indicating that there was an arraignment on this matter and the court required the complaining witness to be present today. I don't see the complaining witness, Ms. Shante Edwards, in the waiting room, Judge. In the event that unidentified telephone number is not Ms. Edwards, the people have no explanation as to why the complaining witness is not present. And at this time, we will not be able to proceed based on the complaining witness's failure to appear today.
I think that unidentified telephone is Ms. Stevens's client that I told to come into court if they couldn't video, and they keep calling in.
Okay.
All right. So today is the date set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ms. Brown, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day and stay safe.
Thank you.
You're welcome. Mr. Taylor, start your video, please. Adjust your camera, please. This is case number 174576101. The people of the state of Michigan versus Jonathan Edward Taylor. The defendant is charged with 1 count of embezzlement. Today is the date set for pretrial conference. Appearances, please.
For the record, John and Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Jonathan Taylor. Mr. Taylor, sir, please unmute and tell the judge your full name.
Jonathan Grant Edward Taylor.
Thank you. Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Taylor, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, the court arraigned this matter and scheduled this pretrial conference and required a representative on behalf of the corporate complainant witness, O'Reilly Auto Parts, to be present for today's pretrial conference. I don't see anyone in the waiting room on behalf of O'Reilly Auto Parts today, Your Honor, and I don't have an explanation as to why the complaining witness did not send a representative for today's pretrial conference. And at this time, the people will not be able to proceed based on the complaining witness's failure to appear today.
Today is the day set for pretrial conference. The complaining witness was required to appear. They failed to appear. The people have no explanation for the failure. They are unable to proceed at this time. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Sir, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you. You too.
Thank you.
That's it. We back, huh?
Sir, can you stop talking? Sir, can you please adjust your camera so that we can see you clearly? Sir, can you turn your camera around so you're not sideways? All right, I'm ready on Anderson. This is case number 205655401, the people of the state of Michigan versus Corey Wendell Anderson. The defendant is charged with 1 count of disorderly conduct. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ivan Land, P65879, appearing on behalf of Corey Anderson, who's present on the screen. Your Honor, we have no objection to holding these proceedings by Zoom. Thank you.
You're welcome. Did you say your P number? I'm sorry.
Yes, P65879, Your Honor.
Mr. Anderson, please unmute and state your name.
Anderson.
Please state your name and turn off your devices. State your name again, please.
Corey Wendell Anderson.
Today is the date set for an arraignment on a bench warrant. Mr. Land, as to the arraignment on the bench warrant,
We stand mute, Your Honor.
court enters a not guilty plea. It appears that Mr. Anderson actually capious from a review that he is on probation to the court. Whoops. That his probation officer is Lori Bumpus. And that he was placed on probation by me, October the 21st, 2020. He is going to have to turn off his other devices.
Okay.
He was ordered.
Yeah.
Sir, what is going on? Let me come up. I'm gonna need you to be quiet. I'm gonna need you to make sure all your devices are turned off. Okay. I don't even know what this means, conservation, restitution. I have no idea what that means. They must have, somebody typed that in wrong, because I don't even know what that means. But his total fines, cost of fees looked like it was $1,020. It was delayed under 771. It's no longer delayed under 771. He was given 3 days credit for time served in jail. I said I would consider an early review after 5 months. And then that was in October 2020. And then he was supposed to come for review in March of 2021. He failed to appear. A bench warrant was issued. And then some kind of way he made a payment, even though it should have been, he had an arraignment on the bench warrant in 21. And then I said he must have started his probation and paid some money by July 14th. When July 14th came, he didn't come. So then he's been in warrant status since July 14th.
So are there new charges of disorderly conduct, or this is just a probation violation?
No, this is the probation violation.
And the original charge was it the curfew for the COVID?
It was some.
Yeah, Your Honor, so I can explain about my client. So my client, in his defense, he lost 7 family members to COVID, and it was after a funeral. Police came past the curfew. I know a lot of judges didn't like that particular law, but it was a law, Your Honor. My client is I
wasn't one of those judges.
Yeah, I know, Your Honor. Outstanding guy, Your Honor, helps people around the community.
Well, why did he go missing?
Your Honor, he's under my watch now. I can't answer that. I know his family. I've been knowing his family my whole life, Your Honor. Let several tenants that could not afford their rent. He didn't try to get the Sears money or anything. He didn't try to evict them. Outstanding gentleman. And I heard this court state that they would remove his 771.1. Your Honor, I would ask that the court not do this. My client can make the full payment of anything he owes today, and he would ask that this matter be closed out, Your Honor. He's not a bad individual, Your Honor. But I did explain to my client, I know COVID was tough on everyone, lost a family member, had a disagreement with some police officers, Your Honor, and he's before this court, which I told him, I know this court is very fair, but if he must obey the laws of this court, Your Honor, and he does apologize. And, as far as his cell phone, Your Honor, he understands that he needs to turn it off, but he has a lot of, I would say, elderly clients. So he actually sleeps with his ringer on and forgot to turn it off because he really does help the community, Your Honor. I know it doesn't sound like that the way he fails to appear in court, but Your Honor, I would ask for you to give him the benefit of the doubt and allow him to keep 771.1 and just close this matter out, Your Honor.
I have to tell Ms. Stevenson sometimes, I said, "Ooh, if I could have my eyes closed and just hear what the lawyer says about their client, that would probably go a long way." But it's not the fact that he had the phone on, it's the fact of how he responded when I said he had to turn the phone off. Right. And right there, it just don't be necessary, right? It's not necessary. So what I did was recite everything that was taking place in the register. That's all I did was recite it.
Yeah.
And then because the law says that if a person, the sentence can only be delayed for 12 months. So that's where we mess up when we don't come back to court in the 12 months. That's not my fault, that's his fault. The law said 12 months. You gotta delay the sentence within 12 months. And if it ain't in 12 months, then it's no longer delayed. Now, it appears that he already paid the money.
Okay.
Right? It looked like he has a zero balance.
Okay.
Looks like he already paid the money. Looks like the great man that you speak of just needed to come to court. That's what it sounds like. Now, he paid the money after the 12 months. He paid the money after the 12 months. Let's see. Looks like he paid the balance. Let me go back up. When did I put him on probation? Maybe not. Let's see. Oh, and he was supposed to do 5 days of community service. So he was supposed to do 5 days of community service and pay the money. He paid the money and he didn't do the 5 days of community service. But let me see when he paid the money. Then that's when he came back to me in 21 and I said he needs to have that money paid, some money paid. Then he did pay.
May I interject when you allow me, Your Honor?
Mr. Flanagan, what does conservation restitution mean?
I'm looking at that too, Your Honor. That must have been an old entry code or something, because I've never seen that before.
Okay. So then I'm looking at May 4th and it says credit card tender. That means he paid $720, right?
Yes,
Okay, and that was before the thing. And then his balance today is 0, right?
yes.
Okay. Yes, Mr. Land.
Your Honor, and I'm not trying to be snotty, but you are the boss, Your Honor. I really don't care what the law says. You can do it, Your Honor.
I would never do that, Mr. Land. I would never do that. Let me
You
say
are the boss,
something.
Your Honor. I know they
I
have
am
laws,
the-
but
I'm the boss. However, I'm the boss and I'm in the judicial branch, and the legislators are the legislators and they make the law. Whether I agree with them or not, it is my unless I believe them to be constitutionally in error, it is my obligation to follow them. Now, that being said, it appears that Mr. Anderson did actually pay the money within the 12 months. He had a 0 balance. He doesn't, I don't know what happened to the community service, but I just have a good feeling that he didn't do it. But let me just say this, and then I'm gonna tell you my decision.
okay.
Yeah, I wasn't one of those judges who didn't like the curfew, because y'all should have had your hand parts at home. It was stay home and stay safe. And then we talking about everybody dying from COVID, and I am so sorry for his loss. I'm sorry for the loss that I suffered. I'm sorry for the loss that you suffered. But if we were staying at home and staying safe, some of us wouldn't have been suffering the loss. And so I am one of the people who took that order very seriously and was irritated at the people that was out in the park and stuff, partying and all of that. So having, trying to make sure that my elderly loved ones were safe and not infected, and all of that, I stayed my hind parts home and I stayed safe. And I lost some people, not in my family, but people who were very near and dear to my heart, because people wasn't staying home and staying safe. But having said that, I am willing to waive the community service because I have a feeling he didn't do it, and I'm not going to even check and see, right? Because I have a good feeling he didn't do it, because he was gone. He'd been gone all that time. He did pay the money. And additionally, I already had given him credit for 3 days. So when I sentenced him, I must have been really feeling real strong about the fact that y'all wasn't staying home and was arguing with the police when they was trying to get you to go home. It don't matter if somebody is deceased. Don't matter if we were out at the funeral. It doesn't matter that we were grieving at the time. If the people told you to go home because it was a curfew, go home. Go grieve on your front porch. Go grieve in your backyard, but get off the city streets. So I don't know. I must have been feeling real strong because I gave him community service and credit for the 3 days. So I'm going to take away the community service. He has the credit for the 3 days served in jail, and he paid the money. I am going to therefore honor the delayed sentence because it was completed within the 12 years, not because I'm the boss and the most important judge in the whole world, but because he completed it during the time that the legislators have set for him to complete it within. So we are going to close Mr. Anderson out of this probation. I will honor the delayed sentence. I will dismiss the matter with prejudice, and I will set aside the conviction. Mr. Land, if you could send that dismissal to the clerk, dismissal with prejudice to the clerk, and then I will have probation submit the order of discharge. Anything further?
Always a pleasure, Your Honor. Thank you so very much.
Always a pleasure. And
Take care, Your Honor. Stay safe.
It's good to see you still doing this.
Yeah, the big
All
day.
right.
The big day is in 2 days, so really?
Yeah.
Yeah. So
I understand. I
Yeah.
definitely understand. All right, well, you take care and be strong, okay?
I see you got your APA looking like a movie star.
That's her, but you know, oh wait, what happened to he must have made a mistake and pushed delete soon as he said that. I was gonna tell him, no, that was you. You, that's your Beyonce look. All right, Mr. Anderson, we'll mail you a copy. Because I didn't remove Mr. Land. I didn't remove him. All right, Miss Stevenson, I got one more case before you. Well, now I don't. They keep leaving. They keep leaving at different times and coming back and leaving and coming back. Oh no, there he is. He's still here. Okay, there he is. I have one more case in front of you. That's Miss Castall's case. And that is Chicago. However, I don't know that the oh, I might have another one, but I'm gonna do a couple of yours and then I'll do I'll also have Cone, the attorney for Cone. Mr. Chicago, I need you to start your camera.
I'm trying to turn my camera on.
Oh, Miss Chicago.
Yes, I'm sorry. Okay.
Ma'am, you coming to court with facial cream on your face? That's inappropriate. Ma'am,
Okay, I'm sorry.
No, listen to me. It's inappropriate and it's disrespectful for you to come on this Zoom with that face cream on the day of your sentencing. This is not a game. It's not a joke. We come to court professionally attired, and that is absolutely disrespectful. Now, please go wash your face and come back prepared for court. I'll bring you back out when I'm ready in a minute when she wash her face. Mr. Landis, I don't believe you would have received a copy of the pre-sentence report because we wouldn't have known that it was some out county prosecutor. Do you need the pre-sentence report?
I do not, Judge. I appreciate the offer, but I think the offer is, I mean, where this is going is stated in the plea agreement. So.
And you don't know me, you might need that report.
And Your Honor, I did.
Send it to him.
I did email it to you, Mr. Landis.
Oh, okay.
Thank you.
Let me make sure. I know he was like, we pretty straightforward. It's nothing straightforward in here. I'm confused anyway by this report right now. What is it? What? Ethnic intimidation stuff. Am I looking at the right report? I'm confused. I must didn't read it. I'm confused. Ms. Casso, on page 1, do you have the report up? Let's see.
I do, Your Honor. So, Your Honor,
Assault and battery. What's this larceny stuff? Do you see this report? And do you see plea agreement and say larceny in a building and larceny pled guilty? That's not right.
no, it's not, Your Honor. She was only charged with the ethnic intimidation, stalking, and the assault and battery. The ethnic intimidation and stalking were dismissed, and she pled to the assault and battery. So that on there is incorrect.
Well, now that makes me nervous about everything else that's in here. But did you go over this with your client?
I did, Your Honor, yes.
Okay. Well, I'll get to that then in a minute. While your client washes her face, I'm going to handle a quick pretrial conference with Ms.
I apologize, Judge, on behalf of Ms. McCoggle. My apologies. I was not aware.
Yeah. All right. Thank you for the apology, though. All right. I'm ready on Fields, Ms. Stevenson, and Holloway, and then I'll be ready on McCoggle.
Thank you, Your Honor.
What did I just say? Fields and what?
Holloway, Your Honor.
Okay. Ms. Fields, start your camera. All right, Ms. Fields isn't starting her camera. Mr. Holloway, I'm ready. On Mr. Holloway, this is case number 145949301, the people of the state of Michigan versus Anthony, maybe Martell or Martez Holloway. The defendant is charged with 1 count of malicious destruction of property, 1 count of assault or assault and battery, and 1 count of arson of personal property. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Anthony Holloway. Mr. Holloway, sir, please tell the judge your full name.
Anthony Martez Holloway.
Thank you. Today is the day set for pretrial conference, Ms. Stevenson.
Thank you, Your Honor. Move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, this is at least the second scheduling of the
I don't
pretrial.
think it is. When were we here before? It's at 8:29.
We were here on July 7th, 2023, and my notes indicate that there's a pretrial held and the court adjourned a pretrial to this day to confirm that the complainant witness is deceased.
Okay, thank you.
You're welcome, Judge. So, Your Honor, this is at least the second scheduling of the pretrial conference, and the people were given information that the complainant witness, Mr. Charles Holloway, was deceased. And although the people could not confirm that, I know Ms. Stevenson sent a copy of the obituary to me, and I did let our victim advocate services know, as they did send out a letter to the last known address. I don't see anyone by the name of Mr. Charles Holloway in the waiting room, Judge. And other than the reasons given as to why he's not present in today's courtroom, Judge, I have no other reason as to why he has not been I'm sorry, Judge, why he's not in the waiting room at this time. So at this time, Your Honor, we will not be able to proceed based on the complainant witness's failure to proceed. I'm sorry, up here.
Ms. Jefferson, can you go put on a jacket for me?
Yes, ma'am.
All right, with respect to Mr. Holloway, today is the day set for pretrial conference, and we were presented with information that the complaining witness is deceased. Ms. Ritter has indicated that she's been unable to officially confirm that, but the court is satisfied that there's a preponderance of the evidence that would suggest that the complaining witness is deceased, and therefore I am going to grant defense counsel's motion and dismiss the matter. It will be without prejudice. Mr. Holloway, we will mail you a copy of the order of dismissal for your record, sir. Have a great day. Stay safe.
That's it.
Thank you, Your Honor.
I'm ready on Jefferson. This is case number 04-628-8801, the people versus LaDon. Middle name may be Nicole Jefferson. Defendant is charged with 1 count of larceny by conversion. Today is the date set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. London Jefferson. Ms. Jefferson, ma'am, please tell the judge your full name.
Yes, my name is London Nicole Jefferson.
Today is the date set for an arraignment. How are we proceeding?
Ms. Jefferson stands mute, waives the reading of the information, asks that a plea of not guilty be entered on her behalf, that the matter be set for a pretrial conference. We would request personal bond, no objection to no contact with the complainants, and permission for Ms. Jefferson to remain in the state of California to where she relocated in August of 2010, Your Honor.
Ms. Ritter.
Judge, the people have no objection to a personal bond or Ms. Jefferson residing in the state of California. However, we are asking for a no contact order for the complainant witnesses in this matter, Your Honor.
Today is the day set for an arraignment in this 2004 case. This case is almost 20 years old. Court is going to enter a not guilty plea. I will set a pretrial conference for September the 18th at 8:36. The complaining witnesses are required to appear. Failure to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness, and the request to reside in California is granted. Anything further?
No, thank you, Judge.
Oh, bond is going to be set at $500 personal.
Nothing further on behalf of Ms. Jefferson with that. Thank you, Your Honor.
All right.
Can I
we're
ask a
set.
question?
Ma'am, I'll send you to a breakout room. You can ask the lawyer. Miss,
Okay.
and I'll send her to number 1.
Thank you, Your Honor.
All right, you're welcome. Ms. Castell, I'm ready.
Yes, Your Honor.
All right, we are ready on case number 23. 559-2601, the people of the state of Michigan versus Meta. Middle names Lynise McCago. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
Pam Landis for the people,
Your P number, please.
64666.
Good morning, Your Honor. Nancy Castor from Neighborhood Defender Service of Detroit, appearing on behalf of Ms. Mita McCoggle, P number 80549.
And ma'am, your full name, please.
Mita Lynise Renee McCoggle.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
No, thank you, Judge.
On behalf of the defense?
Yes, Your Honor. On the first page, I think we discussed this off the record. It indicates that there was a plea agreement for larceny in a building, which was dismissed by party, and then the larceny 200 plea guilty. That information is incorrect, Judge. So I just ask that that be stricken from the pre-sentence report.
Court will strike that from the report.
Thank you, Judge. I have gone over the pre-sentence report with Ms. McCoggle. To our knowledge, it is factually correct. No other additions, deletions, or corrections to be made.
Thank you. With respect to sentencing, is there anything on behalf of the people?
No, thank you, Your Honor.
Anything on behalf of the defense?
Judge, I just ask that the court follow the plea agreement that was entered into between the prosecutor's office and us.
And what is that agreement? Because it's not listed on the reports.
Judge, that agreement was for 9 months reporting probation, which may be telephonic reporting at the discretion of the probation officer, mandatory drug evaluation and following any treatment recommendations, and no contact with the victim, Jaleesa Abad.
That's correct.
Okay. Just for future references, there's never anything that I leave in the discretion of probation. Cheers. Court is going to impose, I apologize, Ms. McCoggle, do you want to make a statement on your own behalf?
So the drug evaluation, will I have to
I didn't say ask me any questions. I said, do you want to make a statement on your own behalf?
No, I guess not.
Okay, then the court is ready to impose sentence. I will do so in the following manner. There is a recommendation from probation for a probationary period of 9 months, which appears to be in line with the sentencing recommendation from between the parties. The court will accept that and sentence Ms. McCago to a term of probation for 9 months. That being a final review date of May the 2nd, 2024 at 10:00 a.m. with the following terms and conditions. Ma'am, you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent from this court. You must make a truthful report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. Oh, give me 1 second. Ms. Stevenson, I'm going to try to send, oh, no, she just went off. Okay, that was distracting. You must pay the following fines, costs, and fees. The court is going to impose the mandatory cost of $210. Additionally, according to page 5 of the pre-sentence report, it indicates that she was unemployed at the time of the interview, but that she had a job offer with a deli. Ms. Castall, do you know the status of her employment?
Your Honor, that didn't go through, so she is still unemployed.
All right, then the court is going to impose $10 days of community service in lieu of the additional fines, costs, and fees, with the exception, of course, of the cost for the classes. Court is going to, so the total cost is $210. Additionally, ma'am, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. According to the report, your license is suspended and your driving status is ineligible. You shall attend and complete 12 weeks of anger management, preferably through the EVA program. Ma'am, what you doing?
Nothing, just moving to another room.
Right, why? Because I'm in the middle of your sentencing.
I know, I hear you. I'm listening. I was just moving to another room.
Don't move to another room. Otherwise, we're gonna come in person and then we'll never have to move out of that courtroom.
Yes, ma'am.
"12 weeks of anger management, preferably through EVA. She will submit to a mental health evaluation. She will submit to urinalysis once a month for 3 months. If I'm satisfied with the results, then she can discontinue. So that actually means I'm going to impose $30 more on her fines, costs, and fees. So that would be $240. $30 would be for the 36th District Court urine screening. And then you shall pay all outstanding tickets that you have with the 36th District Court or get on an approved payment plan. We're going to come back to me after the 3 months so that I can see if there are any additional referrals needed, if I need to refer her to any specialty court based upon her mental health evaluation or her urinalysis. So the court is going to set a review date for November the 2nd. Hold on, that might not be right. I might not be available. Oh yeah, I am. November the 2nd is the review. At 10:00 a.m. We will mail a copy of this report to the Concord Street address. Probation will contact you at the phone number ending in 4281. Is there anything further with respect to Ms. McCoggle?
Your Honor, I just do have a question for the court, and I don't make a difference. Ms. McCoggle does go and get therapy at Team Wellness. So I don't know if that'll make a difference as to the court's requirement that she submit to a mental health evaluation.
No, thank you for bringing that to my attention. So instead of the mental health evaluation, I am going to indicate that she will continue counseling through Team Wellness. Also, I'm sorry, I forgot to indicate, according to the report, now, based upon this misstep on page 1, I don't know, we're gonna need to confirm, probation will need to confirm this, but it indicates that Ms. McCoggle has 1, 2, 3, 4, 5, 6, 7 warrants for her arrest. She must clear up all outstanding warrants. All right, so she needs to confirm that with probation. Yes, ma'am.
Some of those are from 36. Will she be appointed a misdemeanor attorney so that she can get those taken care of? At least the ones for 36.
I see 2 for 36. Strike that. I see 1, 2, 3, 4, 5 for 36. And the answer to your question, generally speaking, is that House counsel is available to anyone in traffic courtrooms who wants to utilize them.
Thank you very much for
So
that,
she
Judge.
needs to work with her probation officer to make sure she gets a court date for those cases at 36, and then you know, whatever else out with the other ones are out of 43rd District Court.
Thank you, Your Honor.
All right, anything further?
Nothing further from the people. Thank you, Your Honor.
Then we're all set, Ms. McCoggle, until November the 2nd. But Ms. McCoggle, I need to let you clearly understand that when you come on Zoom, we're in court. Don't ever show back up in my courtroom with face cream on your face or walking around. We're
Yes, ma'am.
stationary, seated in an upright position, and ready to attend court at all times while
Yes, ma'am.
we're in court. And I would appreciate it also if you wouldn't try to interrupt me and rush me, right? Let me finish my sentences. Because if you had made a statement, I would have let you finish yours. All right, we are all set. Everybody have a great day and stay safe.
Thank you, Your Honor.
Your Honor, oh, never mind.
She left. I mean, she's mad, but she gets mad at the moment. All right. Have a great day. Good to see you. Stay safe.
You too. Thank you, Mr. Landis.
Thank you.
All right. Okay, Ms. Stevenson. Oh, wait, I got one more person. Ms. Stevenson, I got one more person.
Okay, I understand, Judge.
No, who do you need me to get out?
Mr. Pearson has not been to Breakout, and I don't know the Galaxy or Anya.
Okay, let me, whoops. I sent Miss Fields to the breakout. How'd she get back in the waiting room? You told her to log off?
I did not. She may have had some problems, but I've already talked to her.
She was, I mean, you had a plus sign by her name, but she didn't come on. All right. Miss Anya, please unmute and state your name.
State your name. Christina Fields.
Oh, okay, this is Miss Fields right here. So then I don't know who this, she on 2 devices, so we're gonna delete the other device.
And then can we do her, Judge?
I mean, maybe I'm getting ready to do I'm gonna do her after I do Miss Newsom. Mr. Pearson is not coming. So I'll put him back, nor is this Galaxy, so I'll put them back. I'm gonna need, all right, Miss Cameron, are you there?
Oh, yes, I am, Your Honor. I need to,
all right, you can start video now. Miss Newsom, start your video. All right, this is case number 164467401. The people of the state of Michigan versus Andrea Newsom. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
and good morning, Your Honor, Melinda Cameron appearing on behalf of Ms. Newsom. Ms. Newsom, can you identify yourself for the record, please?
Andrea Newsom.
All right, and your P number, Ms. Cameron?
36048, Your Honor.
Thank you. Today's the date set for a pretrial conference. How are we proceeding?
Well, it's my understanding that Ms. Ritter was to produce the complaining witness today. This is a 2016 incident, and we were asking the court to set this for a pretrial matter in order to attempt to resolve it. If she did not appear here today, it's my understanding there was going to be a dismissal without prejudice.
Ms. Ritter?
Judge, so this matter was scheduled today for a pretrial conference. The court did arraign this matter requiring the complaining witness to be present. I don't see the complaining witness, Ms. Alana Good, in the waiting room by name. In the event the unidentified devices are not Ms. Good, the people have no explanation as to why Ms. Good is not present. And at this time, we would not be able to proceed based on the complaining witness's failure to appear today.
The person on the iPhone, please unmute and state your name.
My name is Alan Applebaum, Your Honor. And I'm trying to start my video, but it won't let me.
That's right. Mr. Applebaum, you came to court identified as an iPhone?
Well, this is my iPhone, but normally it has my name on it with the Zoom. I normally use my iPad or my computer, but I've used my phone 1,000 times, and usually it shows up with my name on it. So I can fix that.
No, that's fine. Is your client with you, Mr. Applebaum?
He's not physically with me, but he should be in the Zoom. I physically saw him this morning, and he absolutely knows about today's hearing at 10:30.
Okay, well, FYI, he's not here.
That doesn't, that's interesting, because I was with him this morning.
Okay, well,
I can put you on, I can call him, I can.
I'm gonna put you back in the waiting room and then you can call him.
Here's what I'll do, Judge, is I'm going to hang up on this. I'm going to go to my iPad, which has my name on it, rezoom in on my iPad, so I'll have my phone separate. Would that be okay?
That's fine, yes.
Okay, I'll redo that right now. Okay, bye now.
Bye-bye.
Yeah.
All right, so today is a day set for pretrial conference. That was not the complaining witness, and this Galaxy is not connecting, so I don't know who this is. Ms. Cameron, are you there?
Yes, Judge.
Yeah, okay, because I didn't know who that iPhone was. I'm sorry. I shuts it down every time. All right, so today is the day set for pretrial. The Galaxy is not connecting, and the iPhone was not the complaining witness. So the court is going to grant defense counsel's motion and dismiss the matter without prejudice for failure of the complaining witness to appear. Ms. Cameron, if you could please submit the order of dismissal without prejudice to Mr. Flanagan, then I'll sign it and get it back to you. And then Ms. Newsome, she will get a copy to you for your records, okay?
Thank you very much, Your Honor. Appreciate it. Thank you so
All
much.
right. You're so welcome. Everybody have a great day and stay safe.
You too. Thank you. God bless.
All right. You're welcome. Thank you.
Can Mr. Flanagan put his email address in the chat?
Oh, Mr. Flanagan, chat her your email.
Okay, doing it right now.
Thank
All
you.
right. Ms. Fields, start the camera.
Christina Fields.
No, ma'am, I didn't ask you to state your name. I said start the camera. This is case number 106075101, the people of the state of Michigan versus Christina Fields. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conferences. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Christina Fields. Ms. Fields, ma'am, please tell the judge your full name.
Christina Fields.
Thank you. Today is the date set for a pretrial conference. How are we proceeding?
On behalf of Ms. Fields, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, this matter was set for pretrial conference. The court arraigned this matter and required the complainant witness to be present for today's pretrial conference. I don't see the complainant witness by name, Mr. John Wimble, in the waiting room. I don't have an explanation as to why Mr. Wimble is not present for today's hearing. So at this time, Your Honor, the people will not be able to proceed based on the complainant witness's failure to appear.
All right, today is the date set for pretrial conference. The complaining witness was required to appear. They have failed to appear and the people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. At this time, ma'am, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you, Judge.
You're welcome. All right. Let's see. I'm ready on Dawson.
It's going to be a plea if that matters.
Oh, it does, but
Okay.
I'll put them back shortly. I mean, briefly. What
Okay.
happened to Halliburton? They left? There's nobody
She
in
was-
the breakout room, correct?
Halliburton was on a phone, so she was supposed to be trying to zoom in
yeah.
or come in.
Okay. All right. Parnell. Is that Parnell and Warren?
Parnell and Warren are both ready.
All right. And what about Perkins? Because actually Perkins was.
Perkins is ready and fast.
All right, I'm gonna do Perkins and then Parnell and Warren. So Perkins first, Parnell, and then Warren. This is case number 224483701, the people of the state of Michigan versus Kimberly Perkins. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Kimberly Perkins. Ms. Perkins, ma'am, please tell the judge your full name.
Kimberly Perkins.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Ms. Perkins, move for dismissal for the complainant's failure to appear, Your Honor.
Ms. Ritter.
Your Honor, this is, I'm sorry, Judge, this matter was arraigned by this court on June 13, 2023, and the court set this for a pretrial conference for today, requiring the complainant witness to be present. I don't see the complainant witness, Ms. Indigo Lawson, in the waiting room by that name, Judge, and I have no explanation as to why Ms. Lawson is not present. So at this time, Your Honor, the people will not be able to proceed based on the complainant witness's failure to appear for today's pretrial conference.
I forgot, Mr. Shimke. That's what happened when you don't put attorney next to your name. All right, today is a date set for pretrial conference. The complaining witness was required to appear. They have failed to appear. People have no explanation for the failure. They are unable to proceed. At this time, the court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ms. Perkins, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day and stay safe.
Thank you so much, Your Honor.
You're welcome. I'm ready on Parnell. This is case number 2045-30301, the people of the state of Michigan versus Joshua Edward Parnell. The defendant is charged with 1 count of driving while license suspended, revoked, denied, 1 count of license plate illegal use. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and Judge, today's set for an arraignment.
Thank you. I'm sorry. That's what I meant, arraignment. Thank you.
Janice Stevenson appearing on behalf of Mr. Joshua Parnell. Mr. Parnell, sir, please unmute and tell the judge your full name.
Joshua Parnell.
Is that your full name, Mr. Parnell?
Joshua Edward Parnell, I'm sorry.
That's okay. Thank you. Today is the date set for arraignment. Ms. Stevenson.
Thank you. Mr. Parnell stands mute, waives the reading of the information. Your Honor, we'd ask that the matter be set for pretrial conference. Due to the nature of the charge, we would request discovery, especially as to count 2. Mr. Parnell is also requesting personal bond. He's been advised that he should not operate a motor vehicle unless he's properly licensed to do so. I do have good contact information for Mr. Parnell, Your Honor.
Court is going to enter a not guilty plea on behalf of Mr. Parnell. I will set the matter for pretrial conference, October the 5th, 2023 at 8:25. Discovery should be submitted by September 5th. Esteban, Ms. Ritter.
Judge Esteban, people have no objection to a personal bond.
Court sets bond in the amount of $1,000 personal bond, no driving without a valid license. No operation of any motor vehicle that is not properly registered. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Parnell. Thank you, Your Honor.
Mr. Parnell, you're all set until October 5th, sir, at 8:25. Have a great day. Stay safe.
Thank you, you too.
Thank you. Ready on Warren. This is case number. Whoops. Hmm. 194455001, the people of the state of Michigan versus LaPortia Warren. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Ms. LaPortia Warren. Ms. Warren, ma'am, please unmute and tell the judge your full name.
LaPortia Warren.
As to the arraignment on the bench warrant, Ms. Stevens.
Stands mute, waives the reading of the information, asks that a plea of not guilty be entered on her behalf, and that review be rescheduled, Your Honor. She did post a $50 bond that we're asking be continued.
So that means Ms. Warren is on probation?
To Lori Bumpus, Your Honor, and I've given Ms. Warren, Ms. Bumpus's telephone number, Ms. Bumpus's email address, Ms. Bumpus's supervisor's telephone number with some explicit instructions as to how she should immediately contact Ms. Bumpus.
Good, because I'm not going to keep reinstating probation. I'm not going to keep doing it. Court is going to set the matter for review, reinstate the probation. matter is set for review October the 5th at 1:30. Anything further?
Nothing on behalf of Ms. Warren, except thank you very much, Your Honor.
All right, then you're all set, ma'am. Have a great day and stay safe.
Thank you.
All right, ready on Dawson, then this is case number 194529101. The people of the state of Michigan versus Demetrius Dawson. Defendant is charged with 1 count of retail fraud. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Demetrius Dawson. Mr. Dawson, sir, please tell the judge your full name.
Demetrius Andre Dawson.
Today is the date set for the arraignment on a bench warrant. Ms. Stevenson adds to the arraignment on a bench warrant.
Thank you. Mr. Dawson stands mute, waives a reading of the information, asks that a plea of not guilty be entered on his behalf. He posted a $10 bond, asks that we move immediately to pretrial conference, Your Honor.
Court will enter a not guilty plea on behalf of Mr. Dawson. Is there any objection from the people as to moving to a pretrial conference?
No objection, George.
As to the pretrial.
Mr. Dawson, having had the benefit of counsel, having had the opportunity to review an advice of rights form, having been advised that the complaining witness Meyer has previously appeared on this matter, Mr. Dawson will now waive his rights incident to trial. He would like to avail himself of an offer from the people, offer the court a plea of guilty to 1 count of retail fraud in the 3rd degree. Believe the people's offer was that the plea would be taken pursuant to MCLA 771 with at least a theft awareness class. Mr. Dawson wants to take advantage of that, Your Honor.
Mr. Dawson, your lawyer has indicated that you want to accept the people's offer. Is that what you want to do?
Yes.
I'm going to share my screen, sir. On it is an advice of rights form. My question to you is, have you had an opportunity to review for yourself or go over with your lawyer your constitutional rights?
Yes.
And did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, you will be giving up your right to a trial.
Yes.
Has anyone threatened you in any way or promised you anything that has not been placed on this record to get you to enter into this plea?
No, Your Honor.
Are you currently on probation or parole?
No.
Finally, drawing your attention to number 11 on the advice of rights form. Do you understand that by entering into this plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to request permission of this court to set aside the guilty plea or request permission of the circuit court to appeal the conviction.
Yes.
With that understanding, do you still want to give up your right to a trial and enter a plea?
Yes.
Ms. Stevenson.
Thank you, Your Honor. Mr. Dawson, on June 11th of 2019, were you present at 21431 Grand River in the city of Detroit, commonly known as Meyer Stores?
Yes.
And while there, did you attempt to take property that you knew Meyer offered for sale from the store without paying for that merchandise?
Yes.
And was the value of that property less than $200?
Yes.
With that, Your Honor, defense is satisfied.
Are the people satisfied?
Your Honor, the people stipulate that the value of the merchandise was $40.94. And with that stipulation, the people are satisfied with the factual basis.
Court is satisfied and receives the stipulation. I will accept the guilty plea to 1 count of Retail fraud less than $200. Having accepted the guilty plea, the court is going to set sentencing for Wednesday, September 13th. Is there any request for pre-sentence investigation?
Not from the people, Judge.
None on behalf of Mr. Dawson, Your Honor.
All right, Wednesday, September the 13th at 8:59. Mr. Dawson, you have a right to be sentenced in person, or you may, well, why is Mr. Shimke on 2 devices? Or you may consent to being sentenced on Zoom. Which do you prefer?
Zoom.
Court sets the matter on Zoom, September 13th. All right, sir, you are all set. Have a great day and stay safe, and we'll see you September 13th.
Okay, you too.
Thank you.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Shimke. You almost stayed in that breakout room. I mean, that waiting room forever.
No, good morning, Judge. I only switched over devices because I went mobile while I was on my phone. So when I saw that I was entered, I just switched to my laptop.
You should have been on that laptop because it has your P number on there, and I would have saw you earlier, but your name just blended in. It just blended in with the rest
I'm
of.
sorry, Judge. I will make that a necessary
That-
change
look,
on my phone.
That's
So,
that's on you because you could have been finished.
Judge, but now I get your undivided attention, so it's okay. I'm a patient guy.
Barely. You barely got my attention. No, I'm just
Fair
playing.
enough.
You always have. Everyone has my undivided attention. I don't know why I scheduled all these sentencings for this day. I do know, but it's been wonderful. All right, Mr. Applebaum's client is also now present. Ms. Stevenson, you never made it to the breakout room with Mr. Pearson, correct?
That's correct, Your Honor, but I think I'll be ready if, you know,
Oh,
if
well,
you could
I
just
was
bring
trying
him
to
in.
okay, I was trying to bring him in. I'm getting ready to do Mr. Cone, who has waited patiently this morning, and then I'm gonna do Mr. Davis, who hasn't been here that long because they were scheduled later in the day. All right, hold on. And then Mr. Cone's case is at 8:59. That indicates to me that I did not order a pre-sentence investigation, so we're gonna proceed. And then Mr. Pearson still isn't connecting. I don't know if you have a number for him, but he's still not connecting. All right, this is case number 204410601, the people of the state of Michigan versus Jared Peter Cone, I think, COAN. The defendant is charged with 1 count of malicious destruction of property, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And good morning, Your Honor. Christopher Shemke appearing on behalf of my client P74025. At this time, we consent to the matter being heard via Zoom.
Thank you. Sir, state your name for the record. Unmute.
My name is Jared Cohen.
Cohen. I kept saying Cone like Joan. Cohen. Today is the date set for sentencing as I indicated off the record. I did not order a pre-sentence investigation. Are the people ready to proceed?
People are ready to proceed, Judge.
Is defense ready to proceed?
Yes, Your Honor.
All right. Anything with respect to sentencing on behalf of the people?
Judge, on behalf of the people, we ask the court to adopt the recommendation for a term of probation, no contact with the complainant witness, Mr. Carlos Tate. Restitution, if any. The people tried to contact Mr. Carlos Tate to get that restitution amount, Judge, and I was unsuccessful in speaking with Mr. Tate. So the people are fine with the court setting restitution at 0 at this time. However, leaving the opportunity for a restitution hearing at the first review if or when Mr. Tate contacts the people regarding the restitution information. In addition to that, Judge, we're asking for or recommending 12 weeks of anger management and 771 if Mr. Cohen is eligible for that, Your Honor. When the people looked at the criminal history in our file, it did look like there was nothing that would prevent Mr. Cohen from being eligible for that, Judge. So we'll leave it in the court's discretion as to the delayed sentence.
All right, Mr. Shimke.
Your Honor, I know Mr. Cohen actually since he was about 11 years old, and there was a period of time where he did have severe substance abuse issues, and that also was a time that included 2020. Since that time, Mr. Cohen is gainfully employed. He has a very strong family support system. I don't believe that the behavior that was exhibited on that date and time would reflect anything that he would do now. I believe that he's made some very strong and important strides into making himself an adult, and he does have a very successful future in front of him. Judge, this was absolutely directly correlated with substance abuse 3 years ago, but he does not have an anger issue, Judge. He has been very calm, contrite, and he understands that he made a mistake. We have no objection to the restitution, as Mr. Cohen was very clear to me and now wants to make it clear to the court that he does realize that he damaged this individual's property and has no issue making that person complete. We'd respectfully request any leniency, and I'd ask you to judge the caliber Mr. Cohen is demonstrating now, while not relying entirely on his poor decisions 3 years ago. Thank you, Judge.
You're muted, Judge.
And then as soon as I unmuted, I coughed. And I was saying some good stuff. No. Counsel, I was asking you during the 3 years, have your client been involved in any rehabilitative treatment, any alcohol treatment or drug treatment or anything?
I know that he was actively attending NAAA with his father, who this was a family related issue. And I believe that they were for an extended period of time, if not still attending NA and AA and maintaining his sobriety.
Thank you. Mr. Cohen, would you like to make a statement on your own behalf?
Oh, yes, Your Honor. Yeah, I had a substance abuse problem, a drinking problem a couple years ago. And in 2020, I realized that, and I have been 3 years sober from alcohol and drugs. And I got my life together. I'm a mechanic for Corrigan Oil, and that's not the same. I'm not the same person I was 3 years ago. I'm just trying to be an adult, a regular functioning member of society. And I realized what I did was wrong. And if the complainant was here, I would like to apologize to them if I could, and I would like to just make things right.
All right, well, they are not here unless they are this galaxy that I tried to let in several times, but they are not here. All right, so the court is ready to impose sentence. I will do so in the following manner. I am going to impose a 9-month probationary period. And that would, place us with a final review date of May 2nd, 2024, and an interim review date. I'm going to set an interim review date for November. Well, I'm going to set the first review date for November 2nd. And that's going to be the cutoff for any claim of restitution. So that's going to be review and restitution hearing. for Mr. Cohen. And then this is also going to be my order. Remind me, counsel, because even though Mr. Cohen, you should face the sun because the sun is kind of blinding and it's making it a little difficult to see you. That's so much better right there. But remind me, Mr. Shimke, oh, I just lost my train of thought. Hold on, let me muster it up. November 2nd. Oh, I really did just lose my train of thought. Okay, I'm gonna try to remember. Oh, I know. Is Mr. Cohen still in the state of Michigan or does
Yes,
he?
Your Honor.
Okay, and is he in the Metro Detroit area or is he like up north or something?
He's in Grosse Ile area, Judge.
Okay, thank you. All right, so I am going to do the following. I'm going to order or the following terms and conditions. I will sentence Mr. Cohen pursuant to delayed sentence for 9 months. And then it's going to be a reporting probation at least for the first 3 months. And then we can switch to non-reporting if he successfully, if he's on track with what I'm going to order. I am going to order mandatory cost of $210, a $200 fine. Restitution is to be determined at that first review. Otherwise, it's going to be set at 0. I am going to impose 3 months of oversight fees at $35 per month. That's a total of $105, and then no assessment fee. So the total fines, costs, and fees is $515, not including if the court orders restitution. And then also, you shall not use or possess any illegal substance. You shall not use or possess any marijuana. You shall not use or possess any opiates without a valid prescription. And you shall not use or possess any alcohol. You shall not drive without a valid license. And you shall attend. Ms. Ritter, you indicated that it was your recommendation for the 12 weeks anger management. Was that in the plea agreement or that was just your recommendation?
That was just a recommendation, Judge.
And if the court decreases it to 6 weeks, is there any objection from the people?
No, Judge.
All right. I'm more interested in seeing what he's doing with his drug and alcohol use. I'm going to reduce the anger management to 6 weeks. I am going to order random urinalysis twice per month for the first 2 months. When we come back for the first review, then I'm going to see what his results are. And if his results are good, if he is still off the wagon, on the wagon. Y'all hear me say off the wagon? Don't receive that. Don't receive that. If he's still celebrating his sobriety, then I won't need to make any other referrals. I am going to order no contact with the complaining witness. And I'm not going to order, any type of treatment or anything, even though this incident, it sounds like he's saying, kind of came up because of his drug or alcohol abuse. So I'm going to, I am going to order this, that he submit to the substance abuse evaluation. I just want to see where he is. I want him to test, see where he is, make sure I don't need to make any referrals to the specialty court. And if his test results are good for those first 2 months, I'm not going to make him keep testing. Okay. Counsel, since I didn't do a pre-sentence investigation, I do need you to contact my courtroom and well, no, Mr. Flanagan, I'm not going to add it in because of where he lives. So they may have to let him go somewhere else. So that'll be up to probation. I apologize. My clerk sent me a message in the chat about the cost of your client's urinalysis. So the chief did make an order about people testing at the court, or I don't think he made an order, but he gave probation a directive, but since Mr. Cohen lives in the Grosse Ile area, then they'll probably have to find another location for him to test. Mr. Applebaum, you're out, if you're driving, you're gonna have to pull over. With respect to Mr. Cohen, Mr. Shimke, if you could call my courtroom and make sure that my clerk has your client's current address and phone number, then
Judge, what's courtroom? I'll call.
okay, 965. Mr. Applebaum, you're killing me with your phone. The angle of your phone is it's not. We're gonna have to do something a little different. 965-2295.
No problem, Judge.
Okay, all right, and then Mr. Cohen, we will mail you a copy of this order for your records, but probation is going to contact you with respect to the urinalysis. Now, Mr. Cohen, when you talk to probation about the urinalysis, you all are going to have to discuss how far you live from 36th District Court and the feasibility of you coming down here to test. Otherwise, they're going to have to find you a place to test somewhere else, okay?
Okay.
Now, the cost might be higher, but based on where you live, it might it might wash out, because if you got to pay, gas or whatever to come down here, then it might still be cheaper for you to test somewhere else, okay?
Okay.
Anything further with respect to Mr. Cohen?
No, Your Honor.
No, thank you, Judge.
We're all set. Have a great day. Stay safe.
Thank you, Judge.
Welcome. All right, Mr. Applebaum, can you bring your camera up? Like, we're literally like looking up.
I'm in my car, but I've got my iPad with me, and I think that should work out there.
Okay, yeah, that's better.
I'll hold it up.
All right, I'm ready on date. Excuse me, I'm ready on Davis. This is case number 23554-6801, the people of the state of Michigan versus Michael Anthony Davis. The defendant is charged with 1 count of malicious destruction of property, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Alan Applebaum on behalf of Mr. Davis.
Your P number, counsel.
36444.
And Mr. Davis, your name for the record, your full name. Unmute.
Michael Anthony Davis II.
Thank you. Today is the date set for sentencing. I've had an opportunity to review the pre-sentence report, but I think this was a case. Remind me, is this the case that Mr. Smith was handling at first?
Yes, Your Honor. If the court recalls, my client took a plea in front of Judge King. I forgot. It's in front of. I have the transcript here. But he took a plea in front of another 36th District Court judge. At that plea hearing, Your Honor, my client had met with Mr. Marvin Smith, who was attorney at the time, and the assistant prosecutor at the time. And my client believes that they made an agreement that my client would plead guilty to the charge, immediately pay the restitution for the items that were allegedly damaged, and then probation would be immediately canceled, I guess, if that's the right word. Yeah. The matter transferred to you, and then at a hearing.
Okay, go ahead, counsel. I'm sorry.
At a hearing a couple of months later, my client, you had indicated that you thought that you might not give that type of sentence because you had not taken the plea and you were not part of that agreement. I had indicated that my client had indicated to me that that agreement had been placed on the record in front of the other judge. I did purchase a transcript, Judge. I do have the transcript, and that was not it was not really placed on the record.
No, it wasn't. I knew it wasn't. When he said that, I knew it wasn't, but go ahead.
I mean, basically, I can read to the court. It says here, when Mr. Davis said, I thought that this was, that was going to be the deal, the court said, all right, if I can't tell you what Judge Bryant is going to do, I can tell you what I would do in a case like this. If everything was paid off and you came for sentencing, I'd probably just close it out right then and wouldn't worry about it. So long as you can show it's paid off, your attorney can motion to have it closed out and probably will. But I can't speak for Judge Bryant, and that's where we're at. So you had indicated to my client that in theory you might, I repeat, you might allow him to withdraw his plea, but you wouldn't really make that decision until the transcript was secured and the language in that portion of the transcript provided to you. And so that's kind of where we're at, Your Honor.
Yeah, I knew that didn't happen when your client said it. Why? Because I know that my colleague who came on the bench the year before I did knows exactly how it works. So when a plea is taken in the felony courtroom, it is automatically sent to the misdemeanor court. If they plead to a misdemeanor, the felony judge can only accept the plea and can never speak for the misdemeanor judge who's going to actually do the sentencing. So I knew that my colleague would not have told Mr. Davis what his sentence was going to be, because there would only be one person that knows exactly what the sentence would be, and that would be me. And then Mr. Davis's attitude was so horrible that day. I mean, it was so horrible that day. I remember it like it just happened yesterday. It was so horrible. In fact, when his lawyer came out of the breakout room, I knew that they had some strong words inside of that breakout room. And then his lawyer asked to be removed. And then Mr. Davis, he left. I think he came back, or he tried to come back or something. And his attitude was so horrible. And then I said, well, I would consider allowing him to withdraw his plea. And then I too read the transcript. And I knew that my colleagues said what he said. And Mr. Davis heard what he heard. And that's why it's a good idea to pay attention and to be cordial in court. Because then the judge comes back and remembers the attitude and behavior of the person who's asking the court to do something. And then the court is not inclined to do what the person is asking them to do, because the court remembers how horrible their attitude was the first time that they came. And I don't even think that we got to even what the terms and conditions of the probation would be, outside of the fact of me letting Mr. Smith know that this isn't some just pay and go. If a person maliciously destroys property, they got an anger problem. It's something else that needs to be addressed. This is a misdemeanor, and it is punishable at least by 90 days in the Wayne County Jail, and up to 2 years probation, up to $500 in fines plus costs. So, Mr. Applebaum, how did you want to proceed?
I'd like to ask Mr. Davis if he still wants to have the opportunity to withdraw his plea. I spoke to him this morning. I didn't. We wanted to see. We wanted to go to court this morning, and he's got. And I don't need, because you had indicated the last time you were not quite sure if you'd even allow him to withdraw his plea, but you didn't make a decision whether he could or couldn't at that time. I wasn't there when Mr. Smith obviously was there, and maybe Mr. Davis was, I'm not trying to make excuses, or maybe a little bit, but I think he was frustrated the last time because, right or wrong, good or bad, he was under the impression that he thought that was the deal. That doesn't make it right. That just means what was in his mind. So I think he was a little bit frustrated with Mr. Smith and or whoever, or maybe he should be frustrated at himself. That I understand.
For not listening when Judge King clearly said, I can't tell you what Judge Bryant is going to do. I could tell you what I would do. And then that's why when he was on this docket, he was doing what he was doing. And then he wanted to be on felonies and I wanted to be on here, and we switched places. And now he can't tell me what to do and I can't tell him what to do. And that's why we're right here, right there.
But I wanted to get that transcript to show him, and he's absolutely read that transcript. So he knows. Okay. He understands.
All right.
So the question, Mr. Davis, is, and I've not seen the pre-sentence report, Your Honor, but Mr. Davis, do you want to go ahead with sentencing with Judge Bryant? Do you want to respectfully ask to withdraw your plea, have the felony charge reinstated, then back to the drawing board? that's, that, I mean, we've talked about it. You got to make a big decision.
Okay, Miss Bryant,
Judge.
Miss Judge Bryant.
Mhm.
Okay, with all due respect, I apologize for being rude. I just felt like I was getting shambled by my former attorney, because what he took me out in the hallway and talked to the prosecutor about, yes, you're right, it wasn't put on record. But they clearly took me out in the hallway and say, take this plea and just pay this money, and I'm not gonna look forward to moving forward and pressing any charges. And then go downstairs, pay the $1,200, and then everything will go away. And then so when the judge got to talking and then it got shifted, that's when I got upset. I wouldn't get upset about nothing else. I mean, I was mad.
Seemed to me like that would have been the appropriate time to ask Judge King to withdraw the plea. Seemed to me like that's why you say, has anyone promised you anything that was not placed on the record in order to get you to make the plea? But your anger was misplaced, and it was misdirected, and it was rude, and it was disrespectful.
Okay.
And having read the transcript, I don't believe that the option of withdrawing the plea is an option. Judge King was clear. Judge King was clear, unequivocally. He said, I can only tell you what I would do.
Okay, and then also, Judge, I want like they sent the papers, it's in the transcript that they sent the papers downstairs for me to go pay. And also, Mrs. Smith filed a motion like a week later.
Couldn't have sent no papers downstairs for you to pay because Judge King cannot impose any sentence. So there was no sentencing. There was no sentencing. Let's be clear. There was no sentencing.
I understand that, but it's in the transcript saying that we are sending the papers downstairs for me to go pay. I stayed downstairs for an hour and the papers never came. I was at the window.
Well, there is some language, Your Honor, in the transcript regarding some paperwork going down to the probation department. But
probation, a referral to probation for a pre-sentence investigation.
I agree with that. That's what I believe.
Okay.
So I don't think there's any language in the transcript that talks about the agreement. I'm just trying to see here whether the standard statements that are made before a plea is taken regarding promises and things like that. And it says, do you understand the rights? And you had an opportunity to talk to your attorney, and then you're waiving your rights. That was the standard thing. Anything regarding a promise of the sentencing, but I don't, let's see here. You're giving up your rights. You have a right to be presumed innocent. He goes through the standard subpoena powers. So I don't think there's any language in that transcript regarding whether any promises were made, though when they got to the last paragraph on the last page of the transcript, Judge King specifically says, this is what I would do, but I'm not Judge Bryant, and she's got to make her own decision. And never was given an opportunity after that statement. It just went right to, okay, you're sentenced, you'll get your sentencing date and be on your way. So there's some frustration on his part, justified or unjustified, as to the procedure of what happened. But that's kind of where we're at, Your Honor.
Well, it's my decision is that I'm not going to allow the withdrawing of the plea.
Then, Your Honor, I haven't had a chance to see the probation report, but so I don't know what the recommendation is. I don't know if you want to give the people a chance to send that to me, whether you can give me the highlights over the phone so I can elocute on his behalf. But I did not get an email or anything in the mail regarding a proposed pre-sentence for it. Now, maybe it was given to Mr. Smith, but I have filed an appearance in this case.
It probably was. The pre-sentence investigation is dated April the 12th, 2023. So it is the original pre-sentence report. We can send it to you and I can adjourn the sentencing, give you an opportunity to go over it with your client. It's a standard recommendation. In fact, it's a little surprising to me of the recommendation for 12 months probation, since Mr. Davis has a previous conviction for aggravated assault. But nonetheless, well, I guess that's not a conviction. It's not.
Yes, Judge, is that probation reporting or non-reporting?
Oh, all of my probations are usually reporting depending on what I order. There is a recommendation for anger management. And because of the way that Mr. Davis always acts when he comes to my courtroom, he definitely needs anger management. So there is a recommendation for anger management.
I hope he's presenting himself professionally this morning, Your Honor. He hasn't raised his voice. He hasn't seemed too frustrated. I think he's been.
I fashion myself a body language expert. That's a part of what I'm gonna do when I leave the bench. And every time I say something that he don't like, I'm from the east side too, 6115 Seneca. Every time I say something he don't like, he rolls his eyes, he grunts, his nose inflects out, his mouth. I'm gonna make money helping people pick juries because I'm gonna watch the body language of the jurors. I fashion myself to be very insightful in that area. So no, he has not yelled and raised his voice today. No, he has not exhibited the behavior that he exhibited before. But it is clear to me that for whatever reason and whatever occurred between Mr. Davis and Mr. Smith, number one, he's not over it. But had he gone into the courtroom with Judge King and actually paid attention to what the judge was saying, we probably wouldn't have all this anger and stuff right now. But there is a recommendation for anger management. Now, there was a recommendation in my previous case for anger management. And then I said, well, I'm going to focus more on this area. So, Madam Prosecutor, is there any objection to me reducing that anger management? And then she said, no objection. Because that's the kind of judge I am. I'm a judge who believes in an individualized sentencing, right? I'm a judge that believes in looking at the circumstances and deciding the sentencing. But from what I see from your client, that recommendation for 12 weeks of anger management, it almost should be 24 weeks. That's what I see. But I probably wouldn't do that, but that's what I see.
So, Mr. Davis, you've kind of got an idea of what there's obviously there appears to be no recommendation of incarceration. Looks like 12 months reporting probation. There's going to be some weeks of possibly of anger management. Do you want to go into a breakout room? Or are you ready to proceed to sentencing? Because you're going to the recommendation is not going to change, whether we delay it or not. And I think
it don't matter. I mean, Judge, listen, I didn't want you to take nothing the wrong way, this, that, and the other, but
no, these comments are not, these comments.
I have been through so much. I'm from the east side off 6 Mile Grass here.
Sir, can you hear me? Am I muted? Am I muted?
Oh, let me see. Oh.
No, I'm not muted. So at this point, I only want to know, are we proceeding with the sentencing today? And if we are, then Mr. Davis will get an opportunity to speak. But right now,
I didn't know that.
No. Is, are we proceeding today? Because I've been through a lot too. Yesterday was the anniversary of my sister's death, who died young after she suffered a stroke. I've been through a lot too.
Yeah.
They thought I had breast cancer. I've been through a lot too.
Right.
I was homeless. I've been through a lot too. We all been through a lot.
Yeah.
We don't come in here and take out our frustrations on the people who've done nothing to you. No, that's not how it works. Now, I've been real patient. So counsel, I'm gonna send you and your client to a breakout room. Then he could tell you if he wants you to go over the report in detail. I will give you an adjournment if you request it, because we did send it to Mr. Smith. And I'm sure Mr. Smith, perhaps he didn't forward it to you. So let's send you both to breakout room number 3.
I think Mr. Davis can answer that question.
Oh, okay. Well, because let me tell you another observation. Remember you said, I said, I was observing and this what and so there's a judge sitting in my office because she's going to help with my docket next week. So she had come in to just, kind of watch and then so I go over the docket with her. She just came in after we started and she got the same feeling about Mr. Davis that I have. She said she from the east side too. She recognized all that aggression too. It's a lot of aggression going on with Mr. Davis. And so maybe he might want to wait, but I mean, I know how to separate. I know how to separate. So are we going to citizen today or am I giving an adjournment?
Mike, you want to go ahead right now or you want to get an adjournment?
No, please, let's adjourn it.
Okay.
No, so yeah. Yeah. Can
All
we
right.
adjourn it, please?
We're gonna adjourn to council, is 23rd a good day for you?
It is a good day. All I have is a 10:30 in probate court. But
Oh,
I'm
wait,
good.
I apologize. Not the 23rd. Excuse me. No, I can't do the 23rd. The 25th, the Friday.
That's fine.
Okay, I can adjourn it to the 25th of August,
What time, Your Honor?
9 o'clock.
And what would be the procedure, if any, Your Honor, for me to get that report? Should I come down to the courthouse to physically?
Oh, no, you don't have to do that. If you could put your email in the chat, or if you could just call the courtroom, Mr. Flanagan will email you the report.
Great, I'll call the courtroom.
Okay, do you have the phone number?
I don't. If you could give that to me, I'm ready.
Okay, 965-2295.
Terrific. I'll do that as soon as
Yeah,
we
he'll email you the report. You don't have to come down and get it.
We'll see you on the 25th at 9 o'clock.
Okay, then everybody have a great day and stay safe.
Okay, you too.
All right. Bye now.
Miss Stevenson, Quentin Pearson, it won't come on, and these other two devices, they wouldn't come in either. I think I'm gonna be done. You
I
want me to try
understand, Your
one more
Honor.
time?
I have been chatting Mr. Pearson and I've sent a text message to the last phone number that I had. I would advise the court that my previous attempts to contact Mr. Pearson at that phone number have been unsuccessful. And last time he didn't come on the screen. So
Well, this time he getting a K-Biz. Because it's at
I
8:35.
understand.
Okay, so I'm
I
gonna
understand, Your Honor.
and then I tried this Galaxy and this iPhone, but it's nothing. I'll try one more time, but after this, I'm done.
Okay.
All right, let's see. Can the person on the iPhone unmute and state your name?
How you doing? My name is Douglas Hill.
All right, Mr. Hill. We've been trying to communicate with you a long time, Mr. Hill. Your case was at 8:36.
I know I had messed up. I went to work when I called on break. I went on break and I tried to call down there and they told me they gave me the number to the courtroom. I called the courtroom and left a message.
All right, let's go ahead and do Mr. Hill. Mr. Hill, hold on, I'm gonna let you turn on your camera. Give me a moment. Well, once I get rid of this galaxy.
Okay.
All right. All right, Mr. Hill, now you can start your video.
Let me see. Start video. Okay.
All right, this is case number 18451. We were just getting ready to leave, Mr. Hill. We were just getting ready to hang up and go home.
Oh man.
Oh, yeah. All right. Case number 184519101. The People versus Douglas Hill Jr. Defendant is charged with controlled substance possession of marijuana. Why is that at 8:36? Possession of marijuana. Today is a day set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Douglas Hill. Good morning, Mr. Hill. Good afternoon, sir. Please tell the judge your full name.
Hey, how you doing? My name is Douglas Hill.
All right, today is the day set for pretrial conference, but it's interesting. It's scheduled at 8:36, but there's no complaining witness. Perhaps the people were going to decide if they could proceed or was interested in proceeding based on the nature of the charge.
If I may, Your Honor.
You may.
So, Your Honor, that is correct. Based on the nature of the charge, the people taking the charge into consideration in the age of the case, the people move to dismiss in the best interest of justice.
Mr. Hill, you held out long enough. You evaded us long enough for it to get legal. All right. In what the people call the best interest of justice, we are going to dismiss the matter without prejudice. We'll mail you a copy of the order of dismissal for your records, okay?
Okay, thank you.
You have a great day. Stay safe. You're welcome.
Your Honor, prior to before Mr. Hill goes off,
Yes.
I'm gonna actually need to confirm his address in a breakout.
Mr. Hill, accept to join the breakout so she
Okay.
can confirm your address so we can mail you a copy of the order, okay?
Yes, ma'am.
Breakout room number 3.
Okay.
All right. Have a great day. Stay safe. Miss Stevenson.
Should I do that now, Judge?
Yes, go ahead. Mr. Flanagan.
Yes, Your Honor.
Can you, I have some copies of the dockets for next week, Tuesday and Wednesday. Can you send me the updated one so I could just make sure that I'm addressing the right stuff with Judge Yancey?
Yes, ma'am. You said Tuesday and Wednesday?
Yeah, the 8th and 9th.